Hello, everyone. Today's case is Bowers versus Hardwick. This is about a Georgia sodomy law that was in effect in the 1980s. I don't know when it was passed, but it's regarding this case. And the court it reached the Supreme Court, and let's see what they said. After being charged with violating the Georgia statute criminalizing sodomy by committing that act with another adult male in the bedroom of his home, Respondent Hardwick, brought suit in federal district court, challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. The court granted the defendant's motion to dismiss for failure to state a claim. The Court of Appeals reversed and remanded, holding that the Georgia statute violated respondent's fundamental rights. Held. The Georgia statute is constitutional. The Constitution does not confer a fundamental right upon homosexuals to engage in sodomy. None of the fundamental rights announced in this court's prior cases involving family relationships, marriage, or procreation bear any resemblance to the right asserted in this case. And any claim that those cases stand for the proposition that any kind of private sexual conduct between consenting adults is constitutionally insulated from state proscription is unsupportable. Against a background in which many states have criminalized sodomy and still do, to claim that a right to engage in such conduct is deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty, is, at best, facetious. There should be great resistance to expand the reach of the due process clauses to cover new fundamental rights. Otherwise, the judiciary necessarily would take upon itself further authority to govern the country without constitutional authority. The claimed right in this case falls far short of overcoming this resistance. The fact that homosexual conduct occurs in the privacy of the home does not affect the result. Sodomy laws should not be invalidated on the asserted basis that majority belief in sodomy is immoral is an inadequate rationale to support the laws. Let me try. Sodomy laws should not be invalidated on the asserted basis that majority belief that sodomy is immoral is an inadequate rationale to support the laws. Reversed. Justice White delivered the opinion of the court, in which Chief Justice Berger, Powell, Rehnquist, and O'Connor joined. Berger and Powell filed concurring opinions. Blackmun filed a dissenting opinion, in which Brennan, Marshall, and Stevens joined. Stevens filed a dissenting opinion, in which Brennan and Marshall joined. Justice White delivered the opinion of the court. In August 1982, Respondent Hardwick, hereafter Respondent, was charged with violating the Georgia statute criminalizing sodomy by committing that act with another adult male in the bedroom of Respondent's home. After a preliminary hearing, the district attorney decided not to present the matter to the grand jury unless further evidence developed. Respondent then brought suit in the federal district court, challenging the constitutionality of the statute insofar as it criminalized consensual sodomy. He asserted that he was a practicing homosexual, that a Georgia sodomy statute, as administered by the defendants, placed him in imminent danger of arrest, and that the statute, for several reasons, violates the federal Constitution. The district court granted the defendant's motion to dismiss for failure to state a claim, relying on Doe versus Commonwealth's attorney for the city of Richmond, which this court summarily affirmed. A divided panel of the Court of Appeals for the 11th Circuit reversed. The court first held that because Doe was distinguishable and in any event had been undermined by later decisions, our summary of affirmance in that case did not require affirmance of the district court. Relying on our decisions in Griswold versus Connecticut, Eisenstadt versus Baird, and Stanley versus Georgia, and Roe v. Wade, the court went on to hold that the Georgia statute violated respondent's fundamental rights because his homosexual activity is a private and intimate association that is beyond the reach of state regulation by reason of the Ninth Amendment and the Due Process Clause of the 14th Amendment. The case was remanded for trial at which to prevail, the state would have to prove that the statute is supported by a compelling interest and is the most narrowly drawn means of achieving that end. Because other courts of appeals have arrived at judgments contrary to that of the 11th Circuit in this case, we granted the Attorney General's petition for certiorari, questioning the holding that the sodomy statute violates the fundamental rights of homosexuals. We agree with petitioner that the Court of Appeals erred and hence reversed its judgment. This case does not require a judgment on whether laws against sodomy between consenting adults in general or between homosexuals in particular are wise or desirable. It raises no questions about the right or propriety of state legislative decisions to repeal their laws that criminalize homosexual sodomy, or of state court decisions invalidating those laws on state constitutional grounds. The issue presented is whether the federal Constitution confers a fundamental right upon homosexuals to engage in sodomy and hence invalidates the laws of the many states that still make such conduct illegal and have done so for a very long time. The case also calls for some judgment about the limits of the court's role in carrying out its constitutional mandate. We first register our disagreement with the Court of Appeals and with respondent that the court's prior cases have construed the Constitution to confer a right of privacy that extends to homosexual sodomy and for all intents and purposes have decided this case. The reach of this line of cases was sketched in Carey v. Population Services International, Pierce v. Society of Sisters, and Meyer v. Nebraska. Were described as dealing with child rearing and education. Prince versus Massachusetts with family relationships, Skinner versus Oklahoma, Exrell Williamson with procreation, Loving versus Virginia with marriage, Griswold versus Connecticut, and Eisenstadt versus Baird with contraception, and Roe v. Wade with abortion. The latter three cases were interpreted as construing the Due Process Clause of the 14th Amendment to confer a fundamental individual right to decide whether or not to beget or bear a child. Accepting the decisions in these cases and the above description of them, we think it evident that none of the rights announced in those cases bears any resemblance to the claimed constitutional right of homosexuals to engage in acts of sodomy that is asserted in this case. No connection between family, marriage, or procreation on the one hand, and homosexual activity on the other has been demonstrated either by the Court of Appeals or by respondent. Moreover, any claim that these cases nevertheless stand for the proposition that any kind of private sexual conduct between consenting adults is constitutionally insulated from state proscription is unsupportable. Indeed, the court's opinion in Carey twice asserted that the privacy right, which the Griswold line of cases found to be one of the protections provided by the Due Process Clause, did not reach so far. Precedent aside, however, respondent would have us announce, as the Court of Appeals did, a fundamental right to engage in homosexual sodomy. This we are quite unwilling to do. It is true that despite the language of the due process clauses of the 5th and 14th Amendments, which appears to focus only on the processes by which life, liberty, or property is taken, the cases are legion in which those clauses have been interpreted to have substantive content, subsuming rights that to a great extent are immune from federal or state regulation or proscription. Among such cases are those recognizing rights that have little or no textual support in the constitutional language. Meyer, Prince, and Pierce fall in this category, as do the privacy cases from Griswold to Carey. Striving to assure itself and the public that announcing rights not readily identifiable in the Constitution's text involves much more than the imposition of the justice's own choice of values on the states and the federal government, the court has sought to identify the nature of the rights qualifying for heightened judicial protection. In Palco v. Connecticut, it was said that this category includes those fundamental liberties that are implicit in the concept of ordered liberty, such that neither liberty nor justice would exist if they were sacrificed. A different description of fundamental liberties appeared in Moore v. East Cleveland, where they are characterized as those liberties that are deeply rooted in this nation's history and tradition. It is obvious to us that neither of these formulations would extend a fundamental right to homosexuals to engage in acts of consensual sodomy. Proscriptions against that conduct have ancient roots. See generally survey on the constitutional right to privacy in the context of homosexual activity of 40 University of Miami Law Review. Sodomy was a criminal offense at common law and was forbidden by the laws of the original 13 states when they ratified the Bill of Rights. In 1868, when the 14th Amendment was ratified, all but 5 of the 37 states in the Union had criminal sodomy laws. In fact, until 1961, all 50 states outlawed sodomy, and today, 24 states and the District of Columbia continue to provide criminal penalties for sodomy performed in private and between consenting adults. Against this background, to claim that a right to engage in such conduct is deeply rooted in this nation's history and tradition, or implicit in the concept of ordered liberty, is at best facetious. Nor are we inclined to take a more expansive view of our authority to discover new fundamental rights embedded in the Due Process Clause. The court is most vulnerable and comes nearest to illegitimacy when it deals with judge-made constitutional law having little or no cognizable roots in the language or design of the Constitution. That this is so was painfully demonstrated by the face-off between the executive and the court in the 1930s, which resulted in the repudiation of much of the substantive gloss that the court had placed on the Due Process Clause of the Fifth and 14th Amendments. There should be, therefore, great resistance to expand the substantive reach of those clauses, particularly if it requires redefining the category of rights deemed to be fundamental. Otherwise, the judiciary necessarily takes to itself further authority to govern the country without express constitutional authority. The claimed right pressed on us today falls far short of overcoming this resistance. Respondent, however, asserts that the result should be different where the homosexual conduct occurs in the privacy of the home. He relies on Stanley v. Georgia, where the court held that the First Amendment prevents conviction for possessing and reading obscene material in the privacy of one's home. If the First Amendment means anything, it means that a state has no business telling a man sitting alone in his house what books he may read or what films he may watch. Stanley did protect conduct that would not have been protected outside the home, and it partially prevented the enforcement of state obscenity laws, but the decision was firmly grounded in the First Amendment. The right pressed upon us here has no similar support in the text of the Constitution, and it does not qualify for recognition under the prevailing principles for construing the 14th Amendment. Its limits are also difficult to discern. Plainly enough, otherwise illegal conduct is not always immunized whenever it occurs in the home. Victimless crimes, such as the possession and use of illegal drugs, do not escape the law where they are committed at home. Stanley itself recognized that its holding offered no protection for the possession in the home of drugs, firearms, or stolen goods. And if respondent's submission is limited to the voluntary sexual conduct between consenting adults, it would be difficult, except by fiat, to limit the claimed right to homosexual conduct while leaving exposed to prosecution adultery, incest, and other sexual crimes, even though they are committed in the home. We are unwilling to start down that road. Even if the conduct at issue here is not a fundamental right, respondent asserts that there must be a rational basis for the law and that there is none in this case other than the presumed belief that a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. This is said to be an inadequate rationale to support the law. The law, however, is constantly based on notions of morality, and if all laws representing essentially moral choices are to be invalidated under the Due Process Clause, the courts will be very busy indeed. Even respondent makes no such claim, but insists that majority sentiments about the morality of homosexuality should be declared inadequate. We do not agree and are unpersuaded that the sodomy laws of some 25 states should be invalidated on this basis. Accordingly, the judgment of the Court of Appeals is reversed. Chief Justice Burger concurring. I join the court's opinion, but I write separately to underscore my view that in constitutional terms, there is no such thing as a fundamental right to commit homosexual sodomy. As the court notes, the proscriptions against sodomy have very ancient roots. Decisions of individuals relating to homosexual conduct have been subject to state intervention throughout the history of Western civilization. Condemnation of those practices is firmly rooted in Judeo-Christian moral and ethical standards. Homosexual sodomy was a capital crime under Roman law. During the English Reformation, when powers of the ecclesiastical courts were transferred to the king's courts, the first English statute criminalizing sodomy was passed. Blackstone described the infamous crime against nature as an offense of deeper malignity than rape, a heinous act, the very mention of which is a disgrace to human nature and a crime not fit to be named. The common law of England, including its prohibition of sodomy, became the received law of Georgia and the other colonies. In 1816, the Georgia legislature passed the statute at issue here, and that statute has been continuously in force in one form or another since that time. To hold that the act of homosexual sodomy is somehow protected as a fundamental right would be to cast aside millennia of moral teaching. This is essentially not a question of personal preferences, but rather of the legislative authority of the state. I find nothing in the Constitution depriving a state of the power to enact the statute challenged here. Justice Powell concurring. I join the opinion of the court. I agree with the court that there is no fundamental right, for example, no substantive right under the Due Process Clause, such as that claimed by respondent Hardwick, and found to exist by the Court of Appeals. This is not to suggest, however, that respondent may not be protected by the Eighth Amendment of the Constitution. The Georgia statute at issue in this case authorizes a court to imprison a person for up to 20 years for a single private consensual act of sodomy. In my view, a prison sentence for such conduct, certainly a sentence of long duration, would create a serious Eighth Amendment issue. Under the Georgia statute, a single act of sodomy, even in the private setting of a home, is a felony comparable in terms to the possible sentence imposed to serious felonies such as aggravated battery, first-degree arson, and robbery. In this case, however, respondent has not been tried, much less convicted and sentenced. Moreover, respondent has not raised the Eighth Amendment issue below. For these reasons, this constitutional argument is not before us. Justice Blackmun, with whom Justice Brennan, Justice Marshall, and Justice Stevens joined dissenting. This case is no more about a fundamental right to engage in homosexual sodomy, as the court purports to declare, than Stanley v. Georgia was about a fundamental right to watch obscene movies, or Katz v. United States was about a fundamental right to place interstate bets from a telephone booth. Rather, this case is about the most comprehensive of rights and the rights most valued by civilized men, namely the right to be let alone. The statute at issue denies individuals the right to decide for themselves whether to engage in particular forms of private consensual sexual activity. The court concludes that subsection 16(6)(2) is valid essentially because the laws of many states still make such conduct illegal and have done so for a very long time. But the fact that the moral judgments expressed by statutes like subsection 16(6)(2) may be natural and familiar ought not to conclude our judgment upon the question whether statutes embodying them conflict with the Constitution of the United States. Like Justice Holmes, I believe that it is revolting to have no better reason for a rule of law than that so it was laid down in the time of Henry IV. Let me try that again. It is revolting to have no better reason for a rule of law than that so it was laid down in the time of Henry IV. It is still more revolting if the grounds upon which it was laid down have vanished long since and the rule simply persists from blind imitation of the past. I believe we must analyze Respondent Hardwick's claim in the light of the values that underlie the constitutional right to privacy. If that right means anything, it means that before Georgia can prosecute its citizens for making choices about the most intimate aspects of their lives, it must do more than assert that the choice they have made is an abominable crime not fit to be named among Christians. In its haste to reverse the Court of Appeals and hold that the Constitution does not confer a fundamental right upon homosexuals to engage in sodomy, the court relegates the actual statute being challenged to a footnote and ignores the procedural posture of the case before it. A fair reading of the statute and of the complaint clearly reveals that the majority has distorted the question this case presents. First, the court's almost obsessive focus on homosexual activity is particularly hard to justify in light of the broad language Georgia has used. Unlike the court, the Georgia legislature has not proceeded on the assumption that homosexuals are so different from other citizens that their lives may be controlled in a way that would not be tolerated if it limited the choices of those other citizens. Rather, Georgia has provided that a person commits the offense of sodomy when he performs or submits to any sexual act involving the sex organs of one person and the mouth or anus of another. The sex or status of the persons who engage in this act is irrelevant as a matter of state law. In fact, to the extent I can discern a legislative purpose for Georgia's 1968 enactment of subsection 16(6)(2), that purpose seems to have been to broaden the coverage of the law to reach heterosexual as well as homosexual activity. I therefore see no basis for the court's decision to treat this case as an as-applied challenge to subsection 16(6)(2), or for Georgia's attempt, both in its brief and at oral argument, to defend subsection 16(6)(2), solely on the grounds that it prohibits homosexual activity. Michael Hardwick's standing may rest in significant part on Georgia's apparent willingness to enforce against homosexuals a law it seems not to have any desire to enforce against heterosexuals. But his claim that 16(6)(2) involves an unconstitutional intrusion into his privacy and his right of intimate association does not depend in any way on his sexual orientation. Second, I disagree with the court's refusal to consider whether 1662 runs afoul of the 8th or Ninth Amendments or the Equal Protection Clause of the 14th Amendment. Respondent's complaint expressly invoked the Ninth Amendment, and he relied heavily before this court on Griswold versus Connecticut, which identifies that amendment as one of the specific constitutional provisions giving life and substance to our understanding of privacy. More importantly, the procedural posture of the case requires that we affirm the Court of Appeals judgment if there is any ground on which respondent may be entitled to relief. This case is before us on petitioner's motion to dismiss for failure to state a claim. It is a well-settled principle of law that a complaint should not be dismissed merely because a plaintiff's allegations do not support the particular legal theory he advances. For the court is under a duty to examine the complaint to determine if the allegations provide for relief on any possible theory. Thus, even if respondents did not advance claims based on the 8th or Ninth Amendments or on the Equal Protection Clause, his complaint should not be dismissed if any of those provisions could entitle him to relief. I need not reach either the 8th Amendment or the Equal Protection Clause issues because I believe that Hardwick has stated a cognizable claim that 1662 interferes with constitutionally protected interests in privacy and freedom of intimate association. But neither the Eighth Amendment nor the Equal Protection Clause is so clearly irrelevant that a claim resting on either provision should be peremptorily dismissed. The court's cramped reading of the issue before it makes for a short opinion, but it does little to make for a persuasive one. Our cases long have recognized that the Constitution embodies a promise that a certain private sphere of individual liberty will be kept largely beyond the reach of government. In construing the right to privacy, the court has proceeded along two somewhat distinct albeit complementary lines. First, it has recognized a privacy interest with reference to certain decisions that are properly for the individual to make. For example, Roe versus Wade, Pierce versus Society of Sisters. Second, it has recognized a privacy interest with reference to certain places without regard for the particular activities in which the individuals who occupy them are engaged. For example, United States versus Caro, Payton versus New York, Rios versus United States. The case before us implicates both the decisional and the spatial aspects of the right to privacy. The court concludes today that none of our prior cases dealing with various decisions that individuals are entitled to make free of The court concludes today that none of our prior cases dealing with various decisions that individuals are entitled to make free of governmental interference bears any resemblance to the claimed constitutional right of homosexuals to engage in acts of sodomy that is asserted in this case. While it is true that these cases may be characterized by their connection to protection of the family, the court's conclusion that they extend no further than this boundary ignores the warning in Moore v. East Cleveland against closing our eyes to the basic reasons why certain rights associated with the family have been accorded shelter under the 14th Amendment's Due Process Clause. We protect those rights not because they contribute in some direct and material way to the general public welfare, but because they form so central a part of an individual's life. The concept of privacy embodies the moral fact that a person belongs to himself and not others nor to society as a whole. And so we protect the decision whether to marry precisely because marriage is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. We protect the decision whether to have a child because parenthood alters so dramatically an individual's self-definition, not because of demographic considerations or the Bible's command to be fruitful and multiply. And we protect the family because it contributes so powerfully to the happiness of individuals, not because of a preference or stereotypical households. The court recognized in Roberts that the ability independently to define one's identity that is central to any concept of liberty cannot truly be exercised in a vacuum. We all depend on the emotional enrichment from close ties with others. Only the most willful blindness could obscure the fact that sexual intimacy is a sensitive, key relationship of human existence central to family life, community welfare, and the development of human personality. The fact that individuals define themselves in a significant way through their intimate sexual relationships with others suggests in a nation as diverse as ours that there may be many right ways of conducting those relationships, and that much of the richness of a relationship will come from the freedom an individual has to choose the form and nature of these intensely personal bonds. In a variety of circumstances, we have recognized that a necessary corollary of giving individuals freedom to choose how to conduct their lives In a variety of circumstances, we have recognized that a necessary corollary of giving individuals freedom to choose how to conduct their lives is acceptance of the fact that different individuals will make different choices. For example, in holding that the clearly important state interest in public education should give way to a competing claim by the Amish to the effect that extended formal schooling threatened their way of life, the court declared, there can be no assumption that today's majority is right and the Amish and others like them are wrong. A way of life that is odd or even erratic, but interferes with no rights or interests of others is not to be condemned because it is different. The court claims that its decision today merely refuses to recognize a fundamental right to engage in homosexual sodomy. What the court really has refused to recognize is the fundamental interest all individuals have in controlling the nature of their intimate associations with others. The behavior for which Hardwick faces prosecution occurred in his own home, a place in which the 14th Amendment attaches special significance. The court's treatment of this aspect of the case is symptomatic of its overall refusal to consider the broad principles that have informed our treatment of privacy in specific cases. Just as the right to privacy is more than the mere aggregation of a number of entitlements to engage in specific behavior, so too, protecting the physical integrity of the home is more than merely a means of protecting specific activities that often take place there. Even when our understanding of the contours of the right to privacy depends on reference to a place, the essence of a Fourth Amendment violation is not the breaking of a person's doors and rummaging of his drawers, but rather is the invasion of his indefeasible right of personal security, personal liberty, and private property. The court's interpretation of the pivotal case of Stanley versus Georgia is entirely unconvincing. Stanley held that Georgia's undoubted power to punish the public distribution of constitutionally unprotected, obscene material did not permit a state to punish the private possession of such material. According to the majority here, Stanley relied entirely on the First Amendment, and thus it is claimed sheds no light on cases not involving printed materials. But that is not what Stanley said. Rather, the Stanley court anchored its holding in the Fourth Amendment's special protection for the individual in his home. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. These are the rights that appellant is asserting in the case before us. He is asserting the right to read or observe what he pleases, the right to satisfy his intellectual and emotional needs in the privacy of his own home. The central place that Stanley gives Justice Brandeis's dissent in Olmsted, a case raising no First Amendment claim, shows that Stanley rested as much on the court's understanding of the Fourth Amendment as it did on the First. Indeed, in Paris Adult Theater 1 versus Slatton, the court suggested that reliance on the Fourth Amendment not only supported the court's outcome in Stanley, but actually was necessary to it. If obscene material unprotected by the First Amendment in itself carried with it a penumbra of constitutionally protected privacy, this court would not have found it necessary to decide Stanley on the narrow basis of the privacy of the home, which was hardly more than a reaffirmation that a man's home is his castle. The right of the people to be secure in their houses, expressly guaranteed by the Fourth Amendment, is perhaps the most textual of the various constitutional provisions that inform our understanding of the right to privacy, and thus I cannot agree with the court's statement that the right pressed upon us here has no support in the text of the Constitution. Indeed, the right of an individual to conduct intimate relationships in the intimacy of his or her own home seems to me to be the heart of the Constitution's protection of privacy. The court's failure to comprehend the magnitude of the liberty interests at stake in this case leads it to slight the question whether petitioner, on behalf of the state, has justified Georgia's infringement on these interests. I believe that neither of the general justifications for 1662 that petitioner has advanced warrants dismissing respondent's challenge for failure to state a claim. First, petitioner asserts that the acts made criminal by the statute may have serious adverse consequences for the general public health and welfare, such as spreading communicable diseases or fostering other criminal activity. Inasmuch as this case was dismissed by the district court on the pleadings, it is not surprising that the record before us is barren of any evidence to support petitioner's claim. In light of the state of the record, I see no justification for the court's attempt to equate the private consensual sexual activity at issue here with the possession in the home of drugs, firearms, or stolen goods, to which Stanley refused to extend its protection. None of the behaviors so mentioned in Stanley can properly be viewed as victimless. Drugs and weapons are inherently dangerous, and for property to be stolen, someone must have been wrongfully deprived of it. Nothing in the record before the court provides any justification for finding the activity forbidden by 1662 to be physically dangerous either to the persons engaged in it or to others. The core of petitioner's defense of 1662, however, is that respondent and others who engage in the conduct prohibited by 1662 interfere with Georgia's exercise of the right of the nation and of the states to maintain a decent society. Essentially, petitioner argues, and the court agrees, that the fact that the acts described in 1662 for hundreds of years, if not thousands, have been uniformly condemned as immoral, is a sufficient reason to permit a state to ban them today. I cannot agree that either the length of time a majority has held its convictions or the passions with which it defends them can withdraw legislation from this court's scrutiny. As Justice Jackson wrote so eloquently for the court in West Virginia Board of Education versus Barnett, we apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. Freedom to differ is not limited to the things that do not matter much. That would be a mere shadow of freedom. The test of its substance is the right to differ as to things that touch the heart of the existing order. It is precisely because the issue raised by this case touches the heart of what makes individuals what they are that we should be especially sensitive to the rights of those whose choices upset the majority. The assertion that traditional Judeo-Christian values proscribe the conduct involved cannot provide an adequate justification for 1662. That certain, but by no means all, religious groups condemn the behavior at issue gives the state no license to impose their judgments on the entire citizenry. The legitimacy of secular legislation depends instead on whether the state can advance some justification for its law beyond its conformity to religious doctrine. Thus, far from buttressing his case, petitioner's invocation of Leviticus, Romans, St. Thomas Aquinas, and Sodomy's heretical status during the Middle Ages undermines his suggestion that 1662 represents a legitimate use of secular coercive power. A state can no more punish private behavior because of religious intolerance than it can punish such behavior because of racial animus. The Constitution cannot control such prejudices, but neither can it tolerate them. Private biases may be outside the reach of the law, but the law cannot directly or indirectly give them effect. No matter how uncomfortable a certain group may make the majority of this court, we have held that mere public intolerance or animosity cannot constitutionally justify the deprivation of a person's physical liberty. Nor can 1662 be justified as a morally neutral exercise of Georgia's power to protect the public environment. Certainly, some private behavior can affect the fabric of society as a whole. Reasonable people may differ about whether particular sexual acts are moral or immoral, but we have ample evidence for believing that people will not abandon morality, will not think any better of murder, cruelty, and dishonesty merely because some private sexual practice which they abominate is not punished by the law. Treason Treason reprinted. Petitioner and the court fail to see the difference between laws that protect public sensibilities and those that enforce private morality. Statutes banning public sexual activity are entirely consistent with protecting the individual's liberty interest in decisions concerning sexual relations. The same recognition that those decisions are intensely private, which justifies protecting them from governmental interference, can justify protecting individuals from unwilling exposure to the sexual activities of others. But the mere fact that intimate behavior may be punished when it takes place in public cannot dictate how states can regulate intimate behavior that occurs in intimate places. This case involves no real interference with the rights of others, for the mere knowledge that other individuals do not adhere to one's value system cannot be a legally cognizable interest, let alone an interest that can justify invading the houses, hearts, and minds of citizens who choose to live their lives differently. It took but 3 years for this court to see the error in its analysis in Minersville School District versus Gobbets, and to recognize that the threat to national cohesion posed by a refusal to salute the flag was vastly outweighed by the threat to those same values posed by compelling such a salute. I can only hope that the court soon will reconsider its analysis and conclude that depriving individuals of the right to choose for themselves how to conduct their intimate relationships poses a far greater threat to the values most deeply rooted in our nation's history than tolerance of nonconformity could ever do. Because I think the court today betrays those values, I dissent. Justice Stevens, with whom Justice Brennan and Justice Marshall joined dissenting. Like the statute that is challenged in this case, the rationale of the court's opinion applies equally to the prohibited conduct regardless of whether the parties who engage in it are married or unmarried, or are of the same or different sexes. Sodomy was condemned as an odious and sinful type of behavior during the formative period of common law. That condemnation was equally damning for heterosexual and homosexual sodomy. Moreover, it provided no special exemption for married couples. The license to cohabit and produce legitimate offspring simply did not include any permission to engage in sexual conduct that was considered a crime against nature. The history of the Georgia statute before us clearly reveals this traditional prohibition of heterosexual as well as homosexual sodomy. Indeed, at one point in the 20th century, Georgia's law was construed to permit certain sexual conduct between homosexual women, even though such conduct was prohibited between heterosexuals. The history of the statutes cited by the majority as proof for the proposition that sodomy is not constitutionally protected similarly reveals a prohibition on heterosexual as well as homosexual sodomy. Because the Georgia statute expresses the traditional view that sodomy is an immoral kind of conduct regardless of the identity of the persons who engage in it, I believe that a proper analysis of its constitutionality requires consideration of two questions. First, may a state totally prohibit the described conduct by means of a neutral law applying without exception to all persons subject to its jurisdiction? If not, may the state save the statute by announcing that it will only enforce the law against homosexuals? The two questions merit separate discussion. Our prior cases make two propositions abundantly clear. First, the fact that the governing majority in a state has traditionally viewed a particular practice as immoral is not a sufficient reason for upholding a law prohibiting the practice. Neither history nor tradition could save a law prohibiting miscegenation from constitutional attack. Second, individual decisions by married persons concerning the intimacies of their physical relationship, even when not intended to produce offspring, are a form of liberty protected by the Due Process Clause of the 14th Amendment. Moreover, this protection extends to intimate choices by unmarried as well as married persons. In consideration of claims of this kind, the court has emphasized the individual interest in privacy, but its decisions have actually been animated by an even more fundamental concern. As I wrote some years ago, these cases do not deal with the individual's interest in protection from unwarranted public attention, comment, or exploitation. They deal rather with the individual's right to make certain unusually important decisions that will affect his own or his family's destiny. The court has referred to such decisions as implicating basic values as being fundamental and as being dignified by history and tradition. The character of the court's language in these cases brings to mind the origins of the American heritage of freedom, the abiding interest in individual liberty that makes certain state intrusions on the citizen's right to decide how he will live his own life intolerable. Guided by history, our tradition of respect for the dignity of individual choice in matters of conscience and the restraints implicit in the federal system, federal judges have accepted the responsibility for recognition and protection of these rights in appropriate cases. Society has every right to encourage its individual members to follow particular traditions in expressing affection for one another and in gratifying their personal desires. It, of course, may prohibit an individual from imposing his will on another to satisfy his own selfish interests. It also may prevent an individual from interfering with or violating a legally sanctioned and protected relationship, such as marriage, and it may explain the relative advantages and disadvantages of different forms of intimate expression. But when individual married couples are isolated from observation by others, the way in which they voluntarily choose to conduct their intimate relations is a matter for them, not the state, to decide. The essential liberty that animated the development of the law in cases like Griswold, Eisenstadt, and Carey surely embraces the right to engage in non-reproductive sexual conduct that others may consider offensive or immoral. Paradoxical as it may seem, our prior cases thus establish that a state may not prohibit sodomy within the sacred precincts of the marital bedroom, or indeed between unmarried heterosexual adults. In all events, it is perfectly clear that the state of Georgia may not totally prohibit the conduct proscribed by subsection 1662 of the Georgia Criminal Code. If the Georgia statute cannot be enforced as it is written, if the conduct it seeks to prohibit is a protected form of liberty for the vast majority of Georgia's citizens, the state must assume the burden of justifying a selective application of its law. Either the persons to whom Georgia seeks to apply its statute do not have the same interest in liberty that others have, or there must be a reason why the state may be permitted to apply a generally applicable law to certain persons that it does not apply to others. The first possibility is plainly unacceptable. Although the meaning of the principle that all men are created equal is not always clear, it surely must mean that every free citizen has the same interest in liberty that the members of the majority share. From the standpoint of the individual, the homosexual and the heterosexual have the same interest in deciding how he will live his own life, and, more narrowly, how he will conduct himself in his personal and voluntary associations with his companions. State intrusion into the private conduct of either is equally burdensome. The second possibility is similarly unacceptable. A policy of selective application must be supported by a neutral and legitimate interest, something more substantial than a habitual dislike for or ignorance about the disfavored group. Neither the state nor the court has identified any such interest in this case. The court has posited as a justification for the Georgia statute the presumed belief of a majority of the electorate in Georgia that homosexual sodomy is immoral and unacceptable. But the Georgia electorate has expressed no such belief. Instead, its representatives enacted a law that presumably reflects the belief that all sodomy is immoral and unacceptable. Unless the court is prepared to conclude that such a law is constitutional, it may not rely on the work product of the Georgia legislature to support its holding. For the Georgia statute does not single out homosexuals as a separate class meriting special disfavored treatment. Nor indeed does the Georgia prosecutor even believe that all homosexuals who violate this statute should be punished. This conclusion is evident from the fact that the respondent in this very case has formally acknowledged in his complaint and in court that he has engaged and intends to continue to engage in the prohibited conduct, yet the state has elected not to process criminal charges against him. As Justice Powell points out, moreover, Georgia's prohibition on private consensual sodomy has not been enforced for decades. The record of non-enforcement in this case and in the last several decades belies the Attorney General's representations about the importance of the state's selective application of its generally applicable law. Both the Georgia statute and the Georgia prosecutor thus completely failed to provide the court with any support for the conclusion that homosexual sodomy, simpliciter, is considered unacceptable conduct in that state, and that the burden of justifying a selective application of the generally applicable law has been met. The court orders the dismissal of respondent's complaint, even though the state's statute prohibits all sodomy, even though that prohibition is concededly unconstitutional with respect to heterosexuals, and even though the state's post hoc explanations for selective application are belied by the state's own actions. At the very least, I think it's clear at this early stage of the litigation that respondent has alleged a constitutional claim sufficient to withstand a motion to dismiss. I respectfully dissent. Well, that was a good read. And as always, if there's any case you'd like me to read, just drop in the comments and I'm happy to take a look. Thank you.